Hello. Welcome to the Endrew F Supreme Court Case Update. In January 11, 2017, the Supreme Court heard arguments about the Endrew F versus Douglas County School District. On March 22, 2017, the issue was decided and a ruling sent out. This video will seek to explain the impact of the Endrew case, compare it to the Rowley case, and also explain what may have changed as a result of the ruling for school districts. The Endrew case centered around a child who had autism spectrum disorder who attended public school from kindergarten through 4th grade. At the time of the IEP that was to be written for the child to go into 5th grade, the parents argued that the IEP that the school district had presented was very, very similar to previous IEP goals, including very similar goals and objectives. They argued that the child was not making sufficient progress. Because of this, the parents enrolled the child in a private school and then asked the school district to reimburse them for the tuition that they had paid for the child, believing that the child's education was not adequately being provided, and therefore they were not receiving FAPE. It's important to note that with any case that makes it to the Supreme Court, there are many levels of the legal system. In this case, and in others, after IEP meetings where the parents were dissatisfied, they filed a due process motion that went on to a due process hearing. At that point, it went on to lower courts and then ultimately to the 10th Circuit Court of Appeals, where the decision was then forwarded on to the Supreme Court, which heard the case. It's important to note that the Supreme Court did not make a specific determination as to which side was correct in the decision, but rather redefined the standard by which FAPE was determined and then sent that back to the 10th Circuit of Appeals for them to make a decision on the case. Before we can talk about the Endrew case in any great detail, it's important to understand where the term FAPE comes from, Free Appropriate Public Education, and the standard that was set by the Board of Education versus Rowley Supreme Court case in 1982. The Rowley case established FAPE with a two-pronged test. The first prong is that a school district must have complied with IDEA procedures, and secondly, the district has to be able to develop a reasonably calculated IEP to enable the child to receive educational benefits. A common analogy that came along in education sometime after the Rowley case was the idea of what type of car could the services be equated to. And so it has been stated often by a lot of people in special education that the Rowley case established that the school district was not required to purchase or provide services similar to a Cadillac for children, but rather they were required to provide a serviceable Chevrolet. Rowley established among the FAPE definition that small violations of IDEA procedures were not necessarily sufficient to deny a free and appropriate public education to a child. An example of this prong of the definition is that just because a notice of meeting may have been sent giving the parents only 9 days to respond, but yet the parents were still able to make the meeting, technically that might be a procedural violation because the parents weren't appropriately notified in enough time as the law allowed. Whereas if they had received the notice only a day or two before and had not been able to rearrange their schedule to participate in the meeting, their non-participation in the meeting would certainly be a procedural violation because they did not have a chance to be part of the team decision. The second prong of the Rowley case established that a child need only receive some educational benefit. And again, the term some educational benefit was litigated in the 10th Circuit Court. And at that time, it was determined by the 10th Circuit Court that a child is entitled to more than de minimis benefit. Essentially, it has to be more than the minimum, but it didn't go beyond that standard. And so this is the crux of the issue that came up with the Endrew case. Now, moving back from Rowley to Endrew, the Supreme Court reaffirmed that the Rowley two-pronged definition is appropriate. In fact, they decided it was a good law. However, the definition by which a child makes progress was remanded and sent back to the 10th Circuit Court of Appeals. In the ruling, they decided and said that a school must offer an IEP that's reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. So you may be wondering, what the heck does reasonably calculated mean? Reasonably calculated means that as a school district team, we need to make sure that the child is making progress and has a chance to make progress towards challenging goals. For a general education student, reasonable progress would likely mean movement from one grade to the next. But the court went on to make sure that people reading the ruling understood that it's not only about moving from grade to grade, but rather looking at each individual situation to make sure that their IEP is appropriately developed and ambitious in light of their specific circumstances. The Supreme Court went on to say that the adequacy of a given IEP turns on the unique circumstances for the child for whom it was created, which means to say that they can't provide a ruling that will be generalized across all settings and all students. In fact, it's inherent within the IEP process that each individual plan is uniquely crafted for the student, and it's crafted by the individuals of that IEP team, which includes the parents, school professionals, general education, and special education teachers. Furthermore, the court went on to say that the school officials must ultimately determine what is and what is not adequate. But it's important to note that once the school officials have made that decision, then ultimately the courts will look back and potentially ask the school district to justify how they made their decision. The court went on to say that school officials must be able to offer a cognate and responsive explanation for their decisions that shows that the IEP is reasonably calculated to enable the child to make progress appropriate in light of its circumstances or his circumstances. So what did the Supreme Court Endrew case actually do? It's important to note again, as I mentioned at the beginning, that this court case actually came from the 10th Circuit Court, and the Supreme Court sent it back to the 10th Circuit Court, only they gave a new definition, the definition that's been mentioned. What it likely means for school districts is that as a school district, we need to go well beyond the minimum services for children with disabilities. It's very likely that if you're in this class and listening to this video, you got into education so that you could provide the absolute best for your students. You hopefully are excited to be working in a school and working with students and are excited to see them learn. For those of you who are doing that and are working hard for that to happen, then likely this court case does not change very much in what you do in your day-to-day lives. Additionally, it's important that you are engaging and listening to parents as part of the planning process for an IEP, that you never simply present, here's what we're going to do, and have the parents just say, okay, fine, we'll do that, but rather actually seek their opinion and then use that in the development of the IEP. Next, it's important that as a school district and as a teacher, you're collecting data and making data-based decisions. Very likely the Endrew case would have never made it to the Supreme Court if a district would have been able to look at a child who was getting a similar IEP from year to year, and instead of rewriting the IEP over and over the same way, would rather have stepped back and said, I wonder what we could do differently so that the child would show growth and continue to learn, and then work as a team along with the parents to make that new plan of action come to fruition. And the last thing that has come out of the Endrew case is related to school districts being required in a court setting to be able to justify their decisions. We need to make sure we have good documentation of our meetings and certainly after our meetings. This would include things like appropriate notices of action, as well as any meeting documentation or meeting notes or staffing summaries, as some school districts call them, about what happened, what was presented to the parents, what services were offered, potentially what things were denied, and then any other dissenting opinions that might come out of that IEP. For example, did the parent agree or disagree? Did the school district agree or disagree? Notes like that can be very important because often, by the time it gets to a court case, somebody as part of the process would likely have forgotten about what they talked about during the IEP meeting. While creating this video, I used a lot of important resources. The first was the Supreme Court's decision on the Endrew case, which can be found at the link provided. You may also go to the Supreme Court website and search for the Endrew case. Next, there was an important document from KASB. I've included that link as well, and it's a summary of the Endrew case from the attorneys from the Kansas Association of School Boards. Lastly, I used some information from rightslaw.com. This information and that website also helped provide information on the Rowley case, as well as the Supreme Court website.